Welcome to another episode of Husch Blackwell's False Claims Act Insights podcast. I'm your host, Jonathan Porter. We've got a fascinating topic to discuss today, and I want to introduce it this way. A few months back in our episode on parallel proceedings, we talked about a bribery case where an active duty Army colonel pled guilty to accepting bribes from a defense contractor. He took dollars in exchange for steering contracts. I think we get the concept of bribes. Government officials taking bribes. There are stories of bribes in sports. Shoeless Joe Jackson allegedly taking bribes to throw the 1919 World Series. FIFA officials allegedly taking bribes for steering the location of the World Cup. I think we get those types of bribes. You take money and then you do some action because of the money. But there's a similar and yet less straightforward concept that has a major impact on False Claims Act enforcement, and that's kickbacks, enforced through the anti-kickback statute. The anti-kickback statute, it does cover straight up bribes, but it also covers a lot more. Drug companies offering certain discounts to patients, those could be kickbacks. Doctors receiving paid trips to go to, an educational conference, those could be kickbacks. A few weeks ago, we talked about a recent False Claims Act trial where a pharmaceutical company lost on the theory that paying physicians to speak at conferences violated the anti-kickback statute. Kickbacks are super complicated. There are safe harbors that apply in some situations. There are statutory exceptions. And infuriatingly to me, there are OIG advisory opinions that approve of some kickbacks that they view to pose minimal risk of fraud or abuse, but that healthcare providers cannot rely on for similar situations. Kickbacks are fascinating to me, and kickback enforcement is fascinating to me. There are a couple of really important cases going on right now that are navigating through the appeals process. And given the importance of those cases to kickback enforcement in general, we're going to spend today's episode talking about kickbacks. Joining me to talk about kickbacks is my good friend, Jim Mooney. Jim is Deputy Attorney General for the state of Georgia and runs Georgia's Medicaid Fraud Division of the Georgia Attorney General's Office. Before his promotion to that post last year, Jim was Assistant Director of the Medicaid Fraud Division and actively investigated and litigated criminal and civil healthcare fraud cases, including a bunch of cases involving kickbacks. And that's how Jim and I became friends. So Jim and I had countless cases together, and I was always impressed by Jim's command of our cases and the law. And so when I thought about putting together an episode on, cutting edge developments in kickback cases, I immediately thought of my friend, Jim Mooney. So Jim, thanks for coming on the podcast. Thanks for telling our listeners a little bit about kickbacks.
Yeah. Hey, Jonathan. Thanks for the big introduction. And I particularly appreciate you setting it up by talking about FIFA officials bribing international sporting events and then segueing almost seamlessly to statutory interpretation and HHS advisory opinion. Thrilled to be here with you.
It's all about framing, buddy. So before we get into the details of kickbacks in healthcare, there is a chance that some of our listeners are not familiar with Medicaid fraud units. So I was hoping that before we start getting into the substance of kickbacks, could you tell our listeners a little bit about your unit, about your job, and how that fits into the overall healthcare enforcement concept?
Yeah, absolutely. The easiest way to start it is to just really think about Medicaid fraud control units as state analogs to U.S. attorneys' offices and HHS OIG. Whereas Medicare and TRICARE and plenty of other programs are all federal dollars, Medicaid is a joint collaboration between the states and the federal government. As a result of that, federal government gave all the states an incentive to get involved in the healthcare fraud enforcement space. That was by making it part of a state Medicaid plan to have what's called a Medicaid fraud control unit. They take various forms. They take various arrays of disciplines, but the net result is most of them are within the state attorney general's office. Typically, you've at least got attorneys and investigators, as well as other supporting personnel, such as auditors that really know how to deal with claims data and financial records, and maybe some specialized investigators as well. Where we fit in is we're there to specifically look at issues that are impacting the state Medicaid programs. It's pretty common for us to interact with folks like yourself when you were at the U.S. Attorney's Office, Department of Justice, HHS OIG, FBI, BCIS, all of the various letters we get involved with, and we have our own of MSCU or MAFUCU.
Got it. Thanks, Jim. I appreciate the acronyms. You can't do, healthcare enforcement without referring to all of the acronyms, all of the letters. So thanks for that. So Jim, in a lot of industries, money in exchange for referrals is common. Bribes, like in FIFA, not common, bad, frowned upon. But, money in exchange for referrals is common in a lot of other industries. So I searched around before we recorded. I found that there were banks, car companies, clothing companies, tax software companies, and of course, your, fill in the blank, big box cable TV company. They're all offering people money if they refer future customers to their company. But that sort of arrangement is not okay in healthcare, Jim. Why is that? What's the hang up in healthcare, and what's the purpose of the anti-kickback statute generally?
Sure. I mean, you have to start with the most logical place is that the reason it's illegal is that Congress has said it's illegal. And that really is one of the fundamental differences, is that Congress passed a statute specific to programs that include public dollars. So one of the things to kind of remember is that the federal anti-kickback statute that we're really talking about has to have that nexus to public federal dollars. There's certainly other enforcement mechanisms in other areas that might come into play, but when we're talking about kickbacks, that's what we're really getting at. The basis for wanting to have an anti-kickback statute was, at its heart, a fear that financial incentives can impact medical judgment. So the anti-kickback statute was passed in large part to try to ensure that those making decisions about what services, what products are delivered to the recipients of federal healthcare dollars are making that judgment based off of what is best for the individual, rather than because they have a particular financial relationship with some third party. Connected to that, and you certainly can't divorce it from the notion of what's best for the patient, is an overall concern with safeguarding federal healthcare dollars and ensuring that there's not an overutilization. As we all know, certain products, certain services are more expensive in the healthcare industry than others. So the related concern is that services that happen to be more expensive, and by virtue of being more expensive, are going to cause more tax dollars to be spent. It's going to drive up the cost of our federally funded programs. They want to ensure that those decisions are similarly being made because it's what's best for the patient and not because it's driving business or because of a third-party relationship. So at the end of the day, that's why the anti-kickback statute is there. Those are kind of the articulated goals and reasons that we have in AKS.
Thanks, Jim. Yeah, that makes perfect sense. To me, when I think of healthcare, you're dealing with federal dollars. Patients aren't paying for stuff in the same way. And so the concerns of doctors, sort of abdicating their oath to treating patients. Yeah, there's a lot of concern there that if they're getting dollars from non-payors, then there's a lot of concern there that all of a sudden they're going to start doing crazy stuff. And those are concerns that aren't necessarily there for your cable TV company where, there's not these other concerns. A couple of weeks ago, John Oliver on HBO talked about the hospice industry. And during that episode, he played video, which I hadn't seen before, of a doctor. It was undercover FBI video, I think, talking about how, hey, I can go to this hospice over here and get paid $250 per referral, and just trying to negotiate, where am I sending my hospice referrals? That's criminal conduct. That's why I think the anti-kickback statute exists, is the ability for physicians to go around and shop, where are my patients going to go? Not thinking where are they going to go get the best treatment, but who's going to pay me the most money. That's why the anti-kickback statute exists. It's at its core, I know a lot of people get frustrated with it on the margin, but at its core, it's doing the right thing, which is making sure that physicians are doing what they should be doing in the best interest of patients and not in the best interest of who's going to pay them the most money. So that, I think, is the anti-kickback statute in a nutshell, designed to protect those things. But Jim, it's interesting. I've got a lot of clients who ask me, now that I'm on this defense side, I have to talk to clients about all these things. And one of the things that they talk about is, hey, this is a criminal statute. Why am I under investigation civilly for this criminal statute? So maybe, Jim, could you tell our listeners a little bit, how does the anti-kickback statute play with the False Claims Act? Is it a predicate to the False Claims Act? How do those two statutes fit together?
Yeah, and I think you're right, is when you talk about the AKS anti-kickback statute on its own, it is a criminal statute, and it really is driven at the types of conduct that you were providing in your example, the physician who's literally saying, I can get paid by this particular provider if I bring my patients over there. And I think that when you and I were working a lot together, those are the exact type of relationships we were looking at, really out there, really obvious, really disconnected from healthcare and all about making money. So how it relates between the False Claims Act and the AKS is you've got to kind of think about it as a Venn diagram. There are certain things that are going to be violations of the False Claims Act that don't have any overlap with the anti-kickback statute. And vice versa, is you have conduct that is covered by the anti-kickback statute that may not give rise to False Claims Act liability. So, for instance, the anti-kickback statute, at least parts of it, are really designed at the actual offer of remuneration or payment or money. Remuneration is a very broad word in this context, and it can take a lot of different forms. But it's really geared at that particular offer. So, for instance, you can, in theory, have a kickback violation that doesn't actually result in a claim being submitted to a federal program. In that case, you could, in theory, have a criminal prosecution for somebody that has violated the anti-kickback statute where there may not be liability under the FCA because no claim was ever submitted. On the other side, obviously, the Federal False Claims Act covers more than just the healthcare industry. The anti-kickback statute is really geared only at the healthcare industry. So the FCA, there's going to be plenty of causes of action that have nothing to do with the anti-kickback statute. And even within the healthcare space, there's plenty of ways that you may have a false claim for purposes of the FCA that don't involve kickback violations. But I think we're all familiar, if you work in this space long enough, you probably know that one of the largest areas of enforcement under the False Claims Act are still violations of the anti-kickback statute. So they've come to be hand in hand. It's nothing new. Violations of the anti-kickback statute for quite a while have been enforced under the False Claims Act. And that's because the anti-kickback statute, because of its place within the enforcement framework and because it's a criminal statute, has been viewed as a material condition of payment for federal healthcare payers. So if you have claims that are tainted by these types of arrangements, the theory has always been that you also have a violation of the False Claims Act. And then in 2010, Congress tried to make it even a little bit more explicit. And I know that we've got some things to discuss on that coming here, but they tried to make it more explicit that when you have claims that are violations of the anti-kickback statute, that they are, in fact, violations of the False Claims Act. There's some special words in there that I know we're going to talk about here that have made that a bit more confusing, but that's kind of the general overlap.
Yeah, perfect segue. Let's talk about that. And I love that you use the word tainted in explaining this because that's the way it's always been done. We'll see if that's the continued approach after these cases are decided. But let's just talk about those. By the way, Venn diagram, perfect way of illustrating that. I love a good Venn diagram. So there's this big appeal in the First Circuit. That's what you're talking about. It's the Regeneron case. And I think there's a related case as well that went the other way within the District of Massachusetts. But very briefly, Regeneron is a drug company that allegedly subsidized drug costs in a way that the Justice Department claims violated the anti-kickback statute. But the drug company had some success convincing the district court that because the kickbacks didn't cause false claims, the government didn't have an actionable False Claims Act case. So, Jim, impossible question for you, and you may have a disclaimer here that you got to do before you answer this question. But here's the impossible question after this disclaimer. Can you explain the kickback causation issue in Regeneron in a way that our listeners can understand? That's a hard ask of you, Jim, but I know you can do it. What you got?
So if I just say no here, that I can't do that, so that's an inappropriate response?
Correct.
Okay. Well, yeah, let me first give my disclaimer. Obviously, I'm still with the government right now. I'm still with the state of Georgia. We're familiar with this litigation. We're named parties in it. So I just need to make the clarification that my appearance here today is not supposed to be construed as the particular position of the state of Georgia. I'm not trying to advertise what I think we may or may not do in this particular litigation, but it's an interesting issue, and I think it's going to come up not only in this appeal, but in a variety of other contexts. So to try to get to the heart of the issue, what you had is a scenario where Regeneron was paying money into a fund that effectively helped patients pay their co-payments for particular drugs. And the two parties were more or less in a dispute about the causation element of a violation of the anti-kickback statute versus False Claims Act liability. And you almost have to set aside all of the things about whether or not this constitutes remuneration, whether or not you've kind of got those other elements, because there's a really particular issue that the First Circuit is being asked to look at. And we kind of talked about it a few minutes ago that in 2010, Congress passed 42 U.S.C., basically a statute. I'm not going to go through that whole site because that gets a little bit boring. And I realized I was about to do that. And I stopped myself. But they basically added on a subsection that claims that result from a violation of the anti-kickback statute are violations of the False Claims Act. And the entire debate seems to be about what it means to result from. And this is where the circuit split happens, is whether or not you've got to have but-for causation, or whether it's sufficient, and this is what we were talking about, taint, or what has sometimes been called sufficient causal connection. So at the end of the day, is if the government says, you have submitted a false claim because it resulted from an anti-kickback statute violation, do you have to show that absent the kickback, there wouldn't have been a claim submitted? And that can be a really difficult standard to meet. And that's kind of what they're going back and forth about. And you are really wading into deep lawyer land here, because the circuit split and what is going to be discussed in the appeal is about statutory construction and plain meaning of statutes versus legislative intent. And if you read the government brief compared to the appellee brief, that's exactly what they're arguing about, is when do you go into legislative intent versus what do you deal with as, plain meaning. The argument being that results from language is more or less common law version of, well, you've got to have but-for causation. So if the government can't show affirmatively that the claim wouldn't have been submitted but for the anti-kickback statute violation, that they lose. And that's what they're dealing with on the appeal.
Yeah. So first of all, job well done. I didn't think you could do that, but that was excellent. You did so much better than I could have. That's a great way of explaining that. So admittedly, I don't think there's anything in the legislative history that says that Congress was trying to change anything in the Affordable Care Act. When they included that resulting from language, nothing suggests that Congress says, hey, this tainted theory, let's do away with that. Nothing like that. So the question is, though, there is Supreme Court precedent that says that phrase, results from or resulting from, means but-for causation. And that gets really, really sticky, because but-for causation is really hard to prove. I know that when I was on your side of the V, I thought very long and hard about what that means, because, think about a doctor who prescribes a certain drug for all of her patients and then gets a bunch of cash and continues to prescribe drugs for all of her patients. Did the cash cause the continued action? That's a really hard thing. Under the old version of the law, under the government's reading in Regeneron, that's still actionable under AKS. I don't know about that. I think a jury would have a hard time saying whether that meets but-for causation on the other way. I'd argue that it does not. So that's a big appeal pending in the First Circuit. I think everyone in our world, Jim, is going to continue to watch that, and we'll do the same. So pivoting a little bit here, Jim, one of the most fascinating aspects to me of the anti-kickback statute is that it can only be violated with a certain mindset. The term in lawyerly world is willfully. And apparently there is a growing dispute about exactly what it means to act willfully. So some may hear that word and think that willful means to, intend to do something, as opposed to doing something by accident or without realizing that you're doing it. But it actually means something more than that. I went back and I pulled the trial transcript from a healthcare fraud case that I had with when I was at DOJ. And I saw that my federal judge told the jury that willfully means to do something voluntarily and purposefully with the intent to do something that the law forbids. That is, with a bad purpose to disobey or disregard the law. That definition appears to be under attack in the highest court in our land, the U.S. Supreme Court, where a relator has sought review of a case called United States ex rel. Hart v. McKesson. So, Jim, tell our listeners what willfully really means and why the Supreme Court is being asked to weigh in on this concept.
Yeah, I mean, and I assume that was a case from the 11th Circuit down here, which, this is another thing where we've got a circuit split. So these words that arise in causation and intent, and we're seeing get challenged a lot more. I mean, especially with the Supreme Court and especially in our area of the world. I mean, Ruan under Title 21, and then we had super value last year. These types of terms are getting challenged to try to figure out and try to come to some sort of consensus about what they mean. So when you were talking about having to have a purpose to do something which the law forbids, I'm in Georgia, which is the 11th Circuit. It's a definition that I'm used to. What happened in Hart is you had the Second Circuit more or less agree. They've more or less kind of come on board and said, yeah, we like this 11th Circuit interpretation. The problem is, and it's what you alluded to leading into it, is that other circuits have taken the opposite tack, where they've really viewed willfully as being one of the two things you mentioned, where willfully is either that the actions you took, you did with purpose. In other words, you didn't do it by mistake or accident, or there's kind of this intermediate land, right? Where willfully means that you're doing something that you know is wrong, but not necessarily unlawful. So it's not as tethered to the idea of a legal duty or responsibility. And so that's what the Supreme Court, and so Hart filed their petition for review. The Supreme Court's now asked the defendants to weigh in on whether or not they should accept the petition or not, which is certainly signaling some sort of interest by them that they might be interested in taking up this issue. And I think it's really to deal with that. It is, what does it mean to be willful? And do you have to know that you are doing something which the law forbids, or do you just have to know that you're performing something that's wrongful? And it's going to be fascinating to watch them weigh in on it, because the underlying conduct in Hart is kind of a theory that for those of us on the government side we're used to, which is they had a product that I think for everybody for these purposes is agreeing. We're going to say, okay, this is a potential inducement. This was potentially something of value that was offered to providers, and their staff received compliance training. And this is something we know about, is that, any good company has compliance training, and the government will always ask for things like, what do you do from a compliance perspective? And so you find those things where they talk about the anti-kickback statute, and you talk about whether or not folks are familiar with the anti-kickback statute. You say, well, if you know about the anti-kickback statute and you offered something of value, then you have violated the anti-kickback statute. And the case probably falls into that gray area that tends to be the point of litigation between the government and companies and clients all the time about, well, what happens if the company doesn't really think that this is actually something that is unlawful? And that's kind of the question that the Supreme Court's going to be weighing in on, or at least potentially weighing in on. And I think when you look at it, particularly in light of things like super value and Ruan, you get into this idea of subjective knowledge and subjective intent. And so it's really a fascinating issue to see whether they take it up, and if so, what they articulate as the standard for willfully, because the last few cycles, they've been reflecting a bigger concern with the notion of subjective intent. And so I think this is another opportunity for them to potentially put their stamp on our law in dealing with it from this subjective intent perspective. So when you ask me what willfully means, if I'm reading tea leaves, I'm starting to think, well, this is probably coming down yet against that subjective intent standard and what they knew and how they reacted to information in their possession.
Yeah, thanks for that, Jim. That's great analysis. And I agree with you. I think you're reading the tea leaves correctly. One of the things I think a lot of agents in healthcare are trained, hey, go look and see what's in their enrollment agreement. So when you sign up to become registered with healthcare to be a healthcare provider for Medicare and Medicaid, you're agreeing that you understand what the anti-kickback statute is. You're not going to, pay or receive kickbacks. I think a lot of agents say, okay, well, you signed an enrollment document saying that you understand this. Therefore, everything you do must be willful. I don't think that's the test. I think there's got to be more. You got to show something. And I can think back of a number of ways that you and I showed willfulness when we were working together. There's a lot of different ways to show willfulness. But I'm really interested to see if the Supreme Court grants cert in this Hart case, because this could have a really, really big impact on anti-kickback statute enforcement. So we're recording this like 10 days after the respondents filed their brief. I like what the respondents said. They initially said, no, we're good. We feel like we don't need to submit a brief in order to defend this in the Supreme Court. Like, actually, you do. Let's hear your argument. And so when we're recording this, the Supreme Court hasn't said whether they'll grant cert or not. But this is regardless of whether they grant cert or not. This is because of the circuit split. This is going to be a big deal. I don't know that McKesson thinks that there's a circuit split, but we'll see where this goes. This is going to be really interesting to follow. So, Jim, last question for you. You've been very generous with your time. One of the things that I'm surprised by now that I've been in private practice for a bit is how nervous clients are about this statute. A lot of my clients come to me in a panic when they realize they've just barely missed a safe harbor, and they want to know whether Jim Mooney is about to bust down my door with an arrest warrant. But I tell them that just because you're not in a safe harbor doesn't mean that you've violated the anti-kickback statute. It's a willful statute. But I also tell them that the types of kickbacks that got my attention at DOJ were egregious. Selling patient data, selling DME orders, selling lab tests, and then creating fake invoices showing hourly marketing arrangements to hide the kickbacks. This is egregious stuff that we worked on together, Jim. And so, Jim, I hope that you'll close out this conversation by telling our listeners about what you see as the biggest priorities when it comes to AKS enforcement going forward. What types of kickback arrangements are you seeing, and what's grabbing your attention from an enforcement lens?
In some ways, the old remains the new. I mean, what you're talking about is still going to always be the enforcement priorities, right? First and foremost, that's what anybody on the government enforcement side is looking for, is scenarios where there's just financial incentives all over the place and very little in regard. And we haven't really seen a slowdown. I mean, you mentioned things like labs and DME. We're still seeing labs and DME, and you can do any sort of internet search and find a lot of press releases on those issues still. If they can pivot a little bit, maybe it'll be compound creams, and then it'll be back braces, and then it'll be something else. But those are still the things that are being focused on. I think that probably the area that is stickiest for everybody. I mean, it's sticky for the government. It's sticky for folks that you're representing. And it's probably the area that we're all wrestle with the most, is scenarios where you have large marketing campaigns and there is a disconnect between how something is set up and how it occurs in practice. And it strikes me that a lot of our longest running investigations and the things that take us the longest to get through and almost assuredly take companies and clients the most amount of time are those scenarios. Because, illegal, illicit kickbacks are easy to see. And it's just finding the actors in those circumstances. I think the ones that are tougher is when you can see that programs were almost assuredly set up with the assistance of attorneys. But by the time they make it to the business people, by the time they make it to the down chain people that are on the ground day to day, you see variances between how something was set up and how it happens in practice. And so that to me is always the risk area, is when you see and you can tell, and it's exactly what you were talking about, what we would look for. We would ask for things like, show me your compliance program, show me your contracts. And a lot of places are pretty good about having the correct papers in place. But the question is what happens when the papers aren't what happens in practice? And then we're getting into all the questions that we've been talking about here between causation and intent. And those are the tough questions. Those are the ones that will remain the tough questions going forward.
Jim, thank you for that. That's really, really helpful. I hope our listeners got a lot out of that. Yeah, I think you're exactly right. The old school kickbacks are just being recycled in new ways. And so that's glad you guys are focusing on those egregious kickbacks. That's excellent. So, Jim, thanks for joining the podcast and telling our listeners about these really interesting, really important cases. Jim, I'm going to put you on the spot and ask you to come back next year when we see some results in these appeals. Can I mark you down for that episode, Jim?
Yeah, you bet, as long as you can still find me.
Awesome. Thanks, Jim. You're the man. I'm grateful for our friendship. And as a Georgia taxpayer, I appreciate the work you're doing, but I reserve the right to retract that if we ever get locked in some sort of dispute that we can't resolve. Okay. So to conclude, the hard part about kickbacks to me is that it's hard to draw the line between the type that we all know are illegal and then the gray area of financial incentives. Like I mentioned a few minutes ago, when I was at DOJ, Jim and I prosecuted a bunch of cases together where marketers were straight up selling DME orders to DME companies for set prices, or, cases where marketers were selling lab tests to labs for set prices, and then coming up with fake paperwork showing hours spent marketing that they could show to the feds or to Jim's office if they ever got investigated, when in actuality, they were just buying orders. That's the sort of thing that is a willful violation of the anti-kickback statute, buying and selling orders and then covering your tracks. But my goodness, there's a lot of gray area out there. There are a lot of financial aspects of the business of healthcare that you can make an argument for being an illegal kickback. I get a lot of calls from healthcare providers who say, hey, we're doing X. We're just outside of this safe harbor. How worried should we be? And those are tough conversations because what I think of as a reasonable business practice isn't always what a DOJ or Mafuku attorney is going to think is reasonable. And moreover, what HHS OIG has said in advisor opinions that particular financial arrangements that are literally violations of the anti-kickback statute, but say that they would choose not to enforce because of minimal risk of fraud or abuse in the financial arrangement, to me complicates the analysis even more. Because again, I've seen less egregious kickbacks seized upon by DOJ. So these issues are hugely important for healthcare, which is 17 to 20% of the nation's economy. You'd hope to have something more concrete, but you don't. This is the landscape we're in. And so we're going to continue to cover these issues on this podcast and elsewhere at Husch Blackwell. And so I hope you enjoyed this episode, this discussion of kickbacks. Subscribe, however you're listening to this. Leave a review, tell your friends. We appreciate any way that you're going to get us on other people's radar. But thanks for listening to this episode. See you next time.